Welcome to meeting number 96 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on February 7, 2023, the committee is meeting in public to begin its study of Bill C-332, an act to amend the Criminal Code, controlling or coercive conduct. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. We have witnesses in the room and witnesses on Zoom, so for the benefit of everyone, let me take a minute to read some of the comments. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either English or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments must be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. We have a substitute clerk today, and welcome. I welcome you here today. And substitute help as well, so welcome as well. And we have others on virtual. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. So I will now welcome our witnesses for our first panel. And avant que je commence, je vous...
And before I begin, I would like to inform you that the sound tests have been conducted for the witnesses and also members participating virtually today. So our three witnesses are, first of all, Luke's Place Support and Resource Centre for Women and Children, Pamela Cross, who's the Advocacy Director, and then there's Regroupement des Maisons pour Femmes Victimes de Violences Conjugales. There we have Karine Barrette, lawyer and project manager, accompanied by Louise Riendeau, who's co-responsible for political affairs. Welcome to you. And virtually as an individual, there's Jennifer Cushion, who's professor at the Faculty of Law, University of Calgary.
Each of the three of you have up to 5 minutes for your opening remarks. Because we have witnesses and we have lots of members wanting to ask really important and good questions, I will say in the beginning, if we terminate the 1 hour and you have not had an opportunity to say everything you wanted to, and that goes for the members as well, pose your question, but if you have not had an opportunity to respond, we urge you to please send us whatever you believe would also help this committee in writing, because I do have to keep track of the time because we also have three witnesses in the second panel. Alors, merci beaucoup, et on commence.
So thank you very much, and let's begin with Ms. Pamela Cross. Please go ahead for 5 minutes.
Good morning. Thank you very much for the opportunity to speak with you. We've provided our brief, and I hope you've all had an opportunity to take a look at that because it elaborates on the points I'm going to make very briefly here this morning. Luke's Place works with women in Ontario who've been subjected to intimate partner abuse through both the delivery of direct services to those who are involved with the family law system and engagement in system change work. While we acknowledge that there are a number of reasons to think criminalizing coercive control could have positive outcomes, we believe the problems with criminalization are greater than the potential benefits. Over the past 40 years, we've seen the many ways in which the criminal law has failed survivors of intimate partner violence. Despite the many legal interventions and initiatives, IPV, including lethal violence, remains a serious social problem in this country. While we absolutely need to find ways to validate the experiences of those subjected to coercive control, we don't think creating a criminal offense is the best way to do this. As with any law reform, criminalizing coercive control will have an impact beyond the criminal law itself. In particular, the intersections between criminal and family law are so deep that it's not possible to make changes to one without impacting the other. We're also concerned, based on the negative consequences that have flowed from Canada's long-standing mandatory charging policies, that a new criminal offence of coercive control could lead, likewise, to women being inappropriately charged, which would have disastrous impacts, including on their family law cases. With respect to Bill C-332 specifically, 3 concerns. First, coercively controlling behaviors are insidious, subtle, and often invisible to anyone outside the relationship. What constitutes coercive control is different from one relationship to another. It builds, with one incident leading to another and then another, and only when all of them are examined in totality can the pattern of abuse be recognized by the survivor herself as well as by outsiders. For this reason, the bill needs a clear and inclusive definition of the prohibited behaviors and what constitutes repeated or continuous engagement if it's to be effective. Second, it also needs a clear and inclusive definition of who it's intended to protect. We encourage you to consider the language used by Ontario's Domestic Violence Death Review Committee, which I'm happy to share in the question period. And third, given the reality that abuse often continues long after separation, especially for women with children, the 2-year time limitation should be removed. So what do we recommend? First, that Parliament not move ahead with Bill C-332 at this time. Second, follow the Mass Casualty Commission's recommendation to establish an expert advisory group to examine whether and how criminal law could better address coercive control. Third, provide training with real accountability measures for police to ensure they understand the prevalence of IPV, including coercive control. Fourth, develop new and mandatory education for crowns and judges with accountability measures. Fifth, fund access to free, independent legal advice for survivors of gender-based violence who are considering accessing the criminal system. Sixth, create a criminal court support worker program to work in collaboration with existing criminal court victim assistance programs. And seventh, fund national stakeholder consultations and discussions about the appropriate use of transformative and restorative justice models as a response to gender-based violence in addition to the existing criminal system. Then and only then, consider how the criminal law might need adaptation to respond effectively to coercive control using a collaborative, consultative process with all stakeholders. Thank you, and I look forward to your questions.
Thank you very much. Deuxièmement,
Secondly, we have the Regroupement des Maisons pour Femmes Victimes de Violences Conjugales. You have the floor. Good morning. We'd like to thank the committee for hearing us today on such an important subject, namely the criminalisation of coercive control. We'd also like to thank MPs Garrison Collins for persevering in their efforts to create this offence. Our regroupement, our association, has 46 shelters for abused women or victims of domestic violence spread throughout Quebec. Our position in favour of the criminalisation of coercive control is based on the expertise of our member shelters, on numerous consultations with partners, and on a vast project to improve judicial practice through the integration of coercive control, which has led us to train over 4,000 Quebec legal actors in the last year. We have also recently gone to meet with a number of stakeholders in England and Scotland to identify the advances and learning generated by the criminalisation of coercive control. All agreed that they would not go back on this. Criminalisation of coercive control has brought about an essential shift in the conversation towards better interventions when it comes to domestic violence. Women who are victims of domestic violence experience a variety of manifestations of control or violence. For the majority of women supported by members, physical violence was not their main reason for seeking services. In addition, amongst those who requested external services, they said they were doing so because of a past relationship. This is not surprising because we know that domestic violence can last for a long time after the end of the relationship. It can drag on for many years. Criminalising coercive control would enable significant progress to be made. From the victim's point of view, recognising the impact of coercive control on women and children would represent a major step forward. The deprivation of liberty and pervasive control that characterise the dynamics of coercive control often have far greater and longer-lasting impacts than physical violence. Coercive control also has an impact on the whole family. Arbitrary rules, the climate of tension and fear imposed on the family affect the well-being of children who are co-victims in their own right. They may be the target of arbitrary rules as well, such as limited access to resources, controlled activities or movement, a ban on seeing friends and relatives. Analysing the accounts of victims and their children in their entirety would enable us to move away from the limiting vision of isolated occurrences, which is not representative of their lived experiences. Criminalising coercive control would enable their experience to be validated. Criminalisation, if accompanied by measures to encourage its enforcement, has the potential to increase victims' confidence in the justice system. From a societal point of view, criminalisation would show that this socially unacceptable behaviour must be taken seriously. While physical violence and feminicide are universally condemned, non-physical violence between intimate partners is still too often normalised and trivialised. Yet the vast majority of women who seek help for domestic violence have experienced coercive control, including multiple tactics to frighten them, isolate, degrade and subordinate them, as well as assaults and threats. Criminalising coercive control would be an important step forward in terms of human rights, and specifically women's rights to safety, dignity, autonomy and freedom. The introduction of coercive control into criminal law has the potential to bring interventions closer to the real-life experiences of victims and at an earlier stage too. While coercive control lies at the heart of domestic violence, the current lack of legislative tools to convict perpetrators leaves judicial actors with very few levers and legal tools to intervene effectively in these situations. During the training that we've offered, many police officers tell us that they're aware of or witness worrying situations involving isolated victims who've been terrorised and humiliated by their partner, but they, the police officers, are unable to intervene because there's no offence that covers these acts. So these situations fall into a legal vacuum. Criminalisation would enable the justice system to take account of the context and history surrounding the way in which domestic violence has unfolded at every stage in the process, from police intervention right up to parole. Lastly, since coercive control is a major predictor of homicide, the creation of a new offence would provide an effective additional tool for breaking the cycle of violence earlier and thus adequately assess the level of dangerousness of a domestic violence situation throughout the proceedings. While we support the introduction of a new offence of coercive control in the Criminal Code, this modification alone will not suffice. Accompanying measures such as training for all the actors involved, the police, prosecutors, judges, is essential, as well as public awareness raising, as well as other conditions that we can come back to. We hope that Bill C-332 will be adopted, but we are proposing also another bill which will attach conditions linked to funding. Thank you very much, Madame Barrette, and I'm sure we can come back to all of this during questions.
To our third witness, Jennifer Koshin, s'il vous plaît. 5 minutes, up to 5 minutes.
Thank you. Good morning, and thank you very much for the invitation to provide input on Bill C-332. I'm joining you this morning from Treaty 7 territory here in Mohkinstsis, which is the traditional territory of the Blackfoot peoples. I am speaking on my own behalf this morning, but some colleagues and I did file a submission with the Department of Justice for its study of coercive control in October of 2023. My co-authors are Janet Mosher, Wanda Wiegers, and Shoshana Harris, and I'm relying on that submission for my remarks this morning. We argue that it is crucial for all actors in the legal system to gain a nuanced, contextual, and intersectional understanding of coercive control, to be able to, for example, support risk assessments and safety planning. However, we do not support the criminalization of coercive control in Bill C-332. because of problems with the current legal treatment of intimate partner violence. We identify several concerns, and I'll focus on 3 sets of those concerns today. First is concerns about the current criminal legal system's handling of intimate partner violence. So the current focus of the criminal law is on incidents of abuse, for example, assault, in which the seriousness of the incident is often tied to physical injury. Embedding an understanding of coercive control, which focuses on patterns rather than incidents of abuse, poses significant challenges for police, prosecutors, and judges. Legal actors may also fail to recognize the range of coercive and controlling tactics that are influenced by systemic racism, colonialism, and other systems of oppression. For example, immigration status can be used as a tool of abuse. However, the current treatment of intimate partner violence by the criminal legal system and its actors raises concerns about their ability to gain this sort of nuanced understanding. For example, police continue to lay dual charges in intimate partner violence cases, with Black, racialized, and Indigenous women being disproportionately criminalized. These problems and broader issues with systemic racism and colonialism have led many women to turn away from the criminal legal system. As I argued before this committee in 2021, we can no longer call these so-called unintended consequences because we know the likelihood that they will occur. Our second set of concerns is with respect to how coercive control is being addressed in the family law system. We're currently reviewing cases under the Divorce Act amendments from 2021, and our early review suggests several concerns. Family law courts are struggling to understand coercive control and continue to approach allegations on an incident-focused basis. Like the criminal legal system, family courts also characterize intimate partner violence as mutual in many cases, which may minimize the harms of the violence to women and children. Family courts have also characterized women's attempts to protect their children from violence as amounting to coercive control itself. Given the willingness of family courts to accept allegations of so-called parental alienation, this feeds into potential findings of coercive control against mothers who risk being criminalized or facing adverse parenting outcomes. These are examples of perpetrators manipulating the legal system against the real victims of coercive control. And unfortunately, courts are sometimes persuaded by these types of arguments because of the ongoing influence of myths and stereotypes about intimate partner violence and its victims, which is again of heightened concern for women experiencing intersecting inequalities. For example, women are often wrongly accused of making false allegations of intimate partner violence to gain a so-called upper hand in family law proceedings. If coercive control were criminalized, yet difficult to prove, that would likely feed into these assumptions and work against women and children in parenting disputes, as well as undermining their safety. It's also important to note that coercive control is defined differently in the proposed criminal amendments and in the Divorce Act, which could lead to misunderstandings and misinterpretations. And then our third set of concerns is with respect to Bill C-332 specifically. The provision has no explicit connection to intimate partner violence. The prohibited conduct is not defined. It's unclear how many repetitions of behavior are required. And this vagueness is
Thank you very much. I hate to interrupt. Thank you very much and appreciate your understanding. We will now move into our first round of 6 minutes questioning per each, and I will start with Mr. Moore.
Thank you, Madam Chair. Professor Koshin, if you wanted to just take 30 seconds maybe to finish your thought there, you can go ahead and do that before I begin my questions.
Thanks very much. I appreciate it. So another concern is with respect to the wording of Bill C-332 and its focus on the significant impact on the complainant, which means the bill and its interpretation will very much rely on the complainant's testimony, which is potentially re-traumatizing. And we also have concerns with the best interest defense in section 264.01, clause 5, which is also subject to manipulation by abusers and myths and stereotypes about supposedly benevolent domestic violence, which may adversely impact disabled survivors especially. Thank you.
Okay, thank you. In January, a woman was killed outside a school in Calgary by a man who had been previously charged on 3 separate occasions, but he was released each time with conditions, including a no-contact order. So in this case, despite a clear and established pattern of behavior, this man was released multiple times, and as we all know, with tragic consequences. We feel that there has to be improvements to the bail system that prevents those that are engaging in domestic violence from being repeatedly released. Professor Koshin, would you care to comment on that situation and if you see that there's a need for improvements to the bail system in light of cases like this one?
Thank you for that question. I think something that's significant about that incident is we still don't know a lot about it, and we don't know, for example, if coercive control was an element of the intimate partner violence that was experienced by the woman who was killed in that case. And so, unfortunately, I think that example actually supports the submission that my colleagues and I make, which is that the current criminal legal system is not working as intended. And even in cases where there are clear incidents of physical intimate partner violence, the system is not protecting women. And our concern is that more training, more responses for the actors in the criminal legal system are needed, and that may include reforms to bail, but that alone will not be sufficient.
Yes, I couldn't agree with you more. The current system is not working, and we've seen a remarkable increase in crime, and part of that should be laid at the feet of our bail system that allows people to continue to re-victimize communities and intimate partners as well. I do have a question for Ms. Barrett. In the bill, there's a 2-year period that you're probably familiar with whereby someone having exited a relationship can then go back, as long as it's below 2 years, for seeking a remedy under this legislation, a charge under coercive and controlling conduct. What do you make of that 2-year period, and do you think it should be reduced? Do you think it should be increased? Do you have any comment on it?
Merci beaucoup pour la question. En fait, ça fait partie des...
Thank you very much. That's part of the amendments that we would like to see under this bill. And one of these is to completely remove this limit, not even just to increase it, because in reality there's no limit to domestic violence post-separation. Lots of victims have said that it drags on for years or decades afterwards. So Criminal Code already has a system in terms of the statutory limits. We leave that in the hands of prosecutors, but we don't think there needs to be a limit of 2 years, because that wouldn't reflect the lived experience of victims.
Thank you. And Ms. Barrett, again, on the some of our contemporaries globally who have passed legislation criminalizing controlling or coercive conduct, including the United Kingdom. What do you make of their experiences? Are there lessons to be learned as we consider at this committee this particular piece of legislation? Are there potential traps that we should avoid? Because obviously we want legislation that serves its intended purpose, and that's to protect the victims of intimate partner violence.
Oui, merci pour la question. En fait, j'ai eu la chance de...
Thank you for that question. Fortunately, I could go to London and Edinburgh to meet with partners in these places where it's been criminalised. There's lots that we can learn from that. Fortunately, in Canada, we're coming after them so we can learn from their reality. First of all, violence post-separation was excluded from the first version of the English legislation. Another major difference is the fact that when it comes to Scotland, that followed on after England, they decided to go for an objective-based approach. So Professor Koshin talked about all the weight that's put on the victim to talk about the significant impact on her life. Well, in Scotland, they decided to go with an objective approach. So it's the reasonable person test or criteria that's been applied. And that makes a big difference. When we had the discussion with partners, they said that was one of the key elements, which means that the Scottish legislation is more successful applying this reasonable person criterion. So there's no re-victimisation when it comes to examination or cross-examination of the victim, and facilitates the work for the prosecutors. Another important element that was mentioned was the fact that you need to train actors before the entry into force of legislation. Thank you very much.
C'est Madame Brière.
Merci. And now over to Madame Brière. Thank you very much, Madam Chair, and thank you to Maître Barrett and Ms. Riendeau for being here. I've had the opportunity to meet with you beforehand, and thank you very much for taking time, and thank you also for the document that you've submitted. That's very helpful, and thank you also for the work that you do with these women who've suffered this type of violence in order to improve the situation for these women and, in fact, for all of us, finally. Now, in your opening remarks, you talked about the tools that are needed to try and facilitate or ensure correct implementation of this new measure. So I'd like to hear a bit more about that in a very practical way, please. As my colleague has just said, training is an essential tool if we want to make sure that all actors understand what coercive control actually is, and there need to be instructions given to police officers and prosecutors, everyone in the whole chain right up to bail. It's very important so that they know how to manage this. We also need to have awareness-raising campaigns so that victims themselves and the public actually understand what this is. And we need to speak with people in these different over-judiciarized persons so that this doesn't worsen their situation. So there are measures that need to be developed, and we want there to be a government bill to actually complement this private member's bill and go further than what a PMB can actually achieve. In the bill, we use a definition which is basically a definition of, well, we don't refer to Section 2, intimate partner. And do you think that could actually cause some confusion with this definition? Yes. The definition which we've got in Section 2 of the Criminal Code is very inclusive, very broad, and we've examined the case law, and there's no time limit there. And there's no reference to being a couple that has the intention to marry. It's very broad. And as case law has already decided on this and established this, I think it would be easy to go with something that's more restrictive. And Section 2 already gives these possibilities. So we would like to go with that particular option in terms of definition. Should we consider including children in this bill? Yes, absolutely, at two levels, children and relatives. First of all, there needs to be presumption that children are identified as co-victims of coercive conduct and controlling conduct. If there's a child involved in the relationship, then the legislator has to reflect the impact on children, whether they're physical or auditory witness, or even just the fact that they're involved in this relationship, and also aggravating factors when it comes to determining the sentence or punishment. Thank you. You've heard from Professor Koshin, and during her opening remarks, she mentioned various aspects. Do you think it's difficult to detect or prove the presence of coercive control? Yes, that's a very important point. It's important to be able to do this, to prove this. Drawing on the Scottish experience, the prosecutors and the police officers find it easier to prove than when we're just looking at isolated incidents of physical violence. Coercive control often is more legitimized or trivialized. So when it comes to looking at bank statements and testimonies from family and colleagues, we can draw on that. But once we really understand what we're talking about here, it's not more difficult to prove than something else. When there are contradictory versions, we can look at the history, the context. That allows us to better determine who is the main aggressor when it comes to these cross-referenced complaints. So if we can have a wider, broader investigation with this type of focus, then it's easier to document this and detect it and sort that all out when we actually have cross-referenced complaints or cross-complaints. So as you've said, it's important to take account of the context. Yes, absolutely is the answer. And that avoids us having a situation where there would be a false allegation of victims. When we discussed this with the English and Scottish legislators, that was one of the concerns, but this has not actually turned out to be an issue either in Scotland or England. In your text, you referred to a concern about the duration of the punishment. Criminal harassment is liable for 10 years, but here you're liable for imprisonment of 5 years. Can you come back to that? Yes, the punishment for us has to actually reflect the impact on victims and the life of women, and the objective seriousness. So criminal harassment is one of the tactics, one of the manifestations of this coercive control. So it's logical for us that it should be 10 years rather than the 5 years that is currently put forward in this bill. So perhaps you're aware of the fact that MPs have received a whole chain of letters asking us to include animals in the bill. And later today, we'll be hearing from a witness specifically on this matter. But I'd like to hear your point of view on that. Well, it's obvious that when there's coercive control, all means are possibly used, and certain people will actually try and worry the victim via the animal, saying next time it will be you rather than the farmed animal or your pet. In Scotland, when they turned to survivors about the wording, that was one of the additions that came in. Pets were added as an example in the drafting of their bill. Thank you. And now I give the floor to Mr. Fortin, and you have 6 minutes. Thank you very much, Madam Chair, and thank you, Madame Barrett and Madame Rideau and Ms. Cross for being with us here today. And I'll start quickly with you, Ms. Cross. In your testimony, you proposed a certain number of recommendations. I believe they were 7. And I've tried to note these down. I haven't found all of these. Now, you've submitted your document in the electronic folder 5 minutes ago, so I haven't had time to read that yet, of course, but I quickly glanced through it and I didn't see the recommendations listed. Could we possibly get these recommendations in writing, or can I find them somewhere in your brief?
I'm also happy to provide you with my speaking notes, which list them.
Merci.
Thank you very much for that. So turning down to Maître Barrett, you answered one of the questions from my colleague, Madame Bruyère, and saying, yes, it perhaps will be easier to prove the aggressive and controlling conduct compared to certain physical violent acts. Do you not fear that the fact that it's easy to prove this would actually lead to slippage where we would accuse people or find them guilty, whereas in reality perhaps it wasn't necessarily what the bill was intending to actually punish? Not everything can be described as coercive control. We're talking about the presence of a pattern, so an investigation would have to be carried out, and we'd have to look at the context, the history, and see that this has been repeatedly carried out, and it's a pattern, it's continuous, and it's been carried out and stretched out over time. So each individual act doesn't need to be coercive control, but we're talking about the lived experience of the victim in a situation where this is dragged out and they've experienced this over a number of years. And the fact that we would have a broad, inclusive definition giving examples would actually give some parameters and make it easier for police officers and prosecutors acting in this space. I'd like to add that when we work with IPV victims, it's quite clear that they're dealing with a continuous, repeated pattern over time. It's not just certain one-off incidents, but this stretches out over weeks or months. Sometimes it might be quicker because sometimes a control is set up very quickly, but it's very, very clear when we talk about this with victims. Now, Maître Barrett, you've just referred to the possibility of having a list of conduct, a list of behaviour. So could one of the two of you give me some examples of what could be included in that list? Of course, there's classic standard examples, for example, taking away identity papers or the car keys, or not wanting your spouse to go to work, for example. But over and above that, are there other examples that you could share with us? Well, there's two ways we can look at this with certain examples. We can look at isolation, abuse, surveying people, threatening, surveying their daily activities, micro-regulation, humiliation, blaming them. And then when it comes to more specific, detailed examples, there's also the question of Australian legislation in Queensland, and we could provide that for you, where they really looked at this in detail as you proposed very specific acts. And we've developed tools when it came to the Improving Judicial Practices Act, and we drew on very practical examples from daily life. So it's important for us to be part of the wording. If you do have examples, that would be very useful to share that with us. Now, turning to another subject, we don't have much time, so sorry that I'm jumping around a bit here. So the proposed Section 263.4.13b little I says that when it comes to implementing this, we're talking about people that are connected if it says they are members of the same household, and then it says are relatives under little double I. Under this provision, relatives, do you have an opinion on this? Should we indicate relatives of the same child, or could there be a situation where you've got two people living in the same household and they're both parents to different children? Have you thought about this aspect of the bill? Well, we wanted to completely replace this section and really draw on the definition of intimate partners that's already been established in the criminal code. So that's why we didn't look into the details of this section here. Now, if parents A and B are parents of one child, or if some of them have a child from another union, the child can still be a victim of coercive conduct. And when it comes to dangerousness and the safety of the child, it's increased when the presence of a child who has come from another previous union. Do I still have time? Okay, 40 seconds. So children who are victims of coercive and controlling conduct, there's lots of different questions that I'd like to put on this. Of course, we'd like parents to be able to control their children, but where do we draw a line between essential conduct, if you like, conduct that can be tolerated, and then intolerable conduct when it comes to parent-child relationships? Here we're not talking about parental discipline. We're talking about children who are co-victims of domestic violence. So it's when there's coercive conduct from the spouse, then it's important to look at the impact on the children as well. Can you give me some examples? Well, for example, a child who's living in a climate of terror because their mother is being subjected to violence by their partner, that means that we would then consider this child to be a co-victim of domestic violence or a victim of coercive conduct, or a child who's going to be injured because they're trying to defend their mom. That's a more direct example, but it's also the fact that we're exposed to this, as we see in the Youth Protection Act in Quebec.
Round one to Mr. Garrison, please.
Thank you very much, Madam Chair, and I want to thank the witnesses for being with us today. But I also want to start with the reminder that we have literally hundreds and hundreds of primarily women working to serve victims of intimate partner violence in this country, and the important work that your groups do each and every day in providing that support. And I think that it is the context, I think most of you will know, for me, in the beginning of the pandemic, when I talked to the frontline social service agencies about what was happening, the social service agencies and the police both reported the spike in intimate partner violence. And I guess I just want to ask a bit about that to the representatives of Regroupement des Maisons de Femmes Victimes de Violence Conjugale. It's a mouthful for me in French. But have you seen a decline in that spike as the pandemic restrictions have receded, or has it stayed at very high levels?
Well, what we've observed is an increase in the requests, and we explain that because in Quebec during the pandemic, there were lots of awareness-raising campaigns because we wanted to reach women who were isolated. So the Quebec government did excellent work on coercive conduct, and our groups have been involved in this, and women really heard this message loud and clear. So now women are seeking help. So it's always difficult to measure the prevalence, but in terms of the service requests, there's been an increase, and we've also seen that our partners with police officers and prosecutors working on this project are more sensitive and alert and alive to of this. The prosecutors now have an instruction that they have to take account of the presence of coercive conduct when it comes to looking at bail.
And I think everyone on the table is clear that the idea of this bill is to provide another tool rather than to provide a solution. And I know all of you have mentioned, all of the witnesses have mentioned other things that are needed. And I just want to thank the Regroupement des Maisons again for pointing out that we can't do that in a private member's bill. So in a private member's bill, we can't require the government to spend money. And so your call for a parallel government bill is quite welcome, and I thank you for that. I want to turn back to your experience with the UK and Scotland, something that you said very quickly, Ms. Riendeau, about the positive impacts that they saw from this bill, because there had been some discussion about how there was a slow uptake at the beginning in both the UK and Scotland, with prosecutors and police not really understanding. And I'm assuming your visit was very recent, so maybe you can give us an update on the impacts.
Oui, en fait,
Yes, the impact. When we talked about with the actors, there was also the pandemic, which slowed down the uptake and the implementation. That was one factor. But when we talked about the actors, all of them said they would never go back on this. It allowed them to really shift the conversation in an essential way in terms of understanding domestic violence on the part of legal actors. And when you also look at the dangerousness linked to coercive conduct, this is a response of the system to this level of danger. So the impact is there, it's visible. It's one tool together with others. There's a question of training. So by training up actors, they'll really understand, and they'll be able to better detect this and be able to better manage the victims. The victims have to also be aware of what coercive conduct actually entails. So all of this is about implementation, but none of them want to step back when it comes to criminalisation of coercive conduct. And in the lessons learned, I'd like to add something. In certain cases, people were training police officers, but not the prosecutors. The police officers were getting mobilised. They were bringing forward complaints, and these weren't actually dealt with by the prosecution services, and the police officers were discouraged. That's why everyone has to be trained simultaneously. So we're proposing that we need to adopt this bill and then delay the implementation to give ourselves time to train people properly before it actually enters into force, to avoid that type of mistake occurring.
There have been some concerns raised about the impact on marginalized women, including immigrant women and Indigenous women, of this bill. And I'm going to ask again to the Regroupement des Maisons about your experience with marginalized women and coercive and controlling behavior, intimate partner violence, and how you think this bill might impact them.
en fait, ce qui se passe, c'est que
Well, what happens is that women from marginalised communities also are subject to coercive conduct. And one of the solutions for us would for them to be part of the conversation in terms of consultations. They need to be round the table to verbalise their problems and their fears and what they're experiencing. That really is essential. We also think that the wording as such will not prevent over-representation, just as the case with the rest of the criminal code. So we have to attack the matter of over-representation while also working on coercive conduct. But of course, it has to be part of the conversation.
Okay. You didn't get a chance to talk about your recommendations, so maybe in just, I know it's very quick, but to say something about the recommendations for changes that you were thinking about.
merci beaucoup de l'opportunité.
Thank you very much for giving us that opportunity. So yes, when it comes to the approach, as I mentioned earlier, we would like to withdraw this question of significant impact. We'd like to have an objective approach instead. So a reasonable person placed in the same circumstances, what would they believe would actually be a probable impact? And also change the mens rea so the author, the perpetrator, would know that the victim is controlled or is afraid that they're being controlled. And then when it comes to the link, as we've already said, we want to withdraw the period of 2 years, and the use of the definition of intimate partner under Section 2 of the Criminal Code is another suggestion. Thank you very much. And now, second round.
I'll go for 5 minutes, 5 minutes, 2.5, 2.5. We'll allow all of that, but we'll watch the timing. So, Mr. Van Popta, please.
Thank you, Madam Chair. And I will start by ceding a couple of minutes to my colleague, Ms. Finley.
Thank you. Madam Chair, I just want to say, having practiced in the family law field for many years before I became a member of Parliament, I am very familiar with the mental and physical devastation of a pattern of coercive control in intimate relationships. And with the utmost respect to our witnesses here, I am going to take a few minutes to interrupt their testimony to address another important matter of justice for women and families in British Columbia. In a moment, I will move a motion that I expect to receive a short debate and hopefully unanimous support so we can return to this important witness testimony on Bill C-332. Mr. Moore gave proper notice of this motion last week, and as his substitute, then I move that the committee call on the Liberal government to ensure that Robert Pickton spends the rest of his life in prison and prevent any re-traumatization of the families of his victims through unnecessary parole hearings, and that this be reported to the House. Madam Chair, with your indulgence, I would like the committee to hear these names: Serena Abbotsway, Mona Wilson, Andrea Joesbury, Brenda Wolfe, Georgina Papin, Marnie Frey, Jacqueline McDonnell, Diane Rock, Heather Bottomley, Jennifer Firminger, Helen Hallmark, Patricia Johnson, Heather Chinnock, Tanya Holick, Sherry Irving, Inga Hall, Tiffany Drew, Sarah DeVries, Cynthia Felix, Angela Jardine, Diana Melnick, Deborah Jones, Wendy Crawford, Carrie Lynn Koski, Andrea Borhaven, Kara Ellis. Chair, these women are the known victims of vile serial killer and rapist Robert Pickton. This monster has bragged of murdering 49 women with a stated objective of murdering 50. Most of these women and their families will never receive the justice they deserve. He was known to prey on vulnerable women suffering from addiction. Pickton would take his victims to his pig farm in Coquitlam, where he would torture them and commit brutal murders, stabbing some while handcuffed, injecting others with antifreeze. After killing his victims, he would feed their bodies to the pigs, leaving behind very little evidence. Needless to say, monsters like him should only leave prison in a body bag. Last week, we learned Robert Pickton has become eligible to apply for day parole. Should his case be reviewed by the parole board, the victims of his families will be forced to relive the trauma they experienced all over again. This is an outrageous insult to the families who continue to suffer. They should not be subjected to further re-traumatization. I want to share their words with this committee. The mother of Stephanie Lane said, quote, "Pickton should not walk on this earth. He does not deserve to take one step out of where he is. He needs to stay where he is until he dies. I've been living in hell. It's been horrible. I always say that I am living in a Stephen King novel. I think of my daughter every single day, but I don't want to think of Robert Pickton every day." Tanya Holick's cousin said, quote, "The fact that he can actually apply is horrific. That threw me right off. I didn't know, and the other families that I'm close to didn't know. Our justice system is horrific. I already don't trust the justice system, and this just makes me not trust it even more, because the fact that a person like this could be let out of jail, it's disgusting," end quote. The community recently held a vigil at the Pickton farm as they brace for the possibility of a parole hearing for the man who has caused them so much pain. At the very least, Canadians should expect our justice system to protect victims of the most heinous crimes. Under Justin Trudeau's watch, the rights of criminals have been consistently prioritized over the rights of victims. I won't relitigate every case, but we have seen a flagrant disregard for victims in the cases of Paul Bernardo's transfer to medium security and Terry Lynn McClintock's transfer to a healing lodge. Just last week, Jeremy Vojkovic, a man who raped and burned a woman alive, was granted temporary leave on Vancouver Island, despite a psychiatric assessment that expressed, quote, grave concern, end quote, over the risk he poses to the public and over the objections of the victim's family. 8 years of Trudeau's radical left agenda has created a system of injustice. Canadians have lost faith in our systems. That's why this committee should take the first step to restoring this trust. My motion calls on Trudeau's government to ensure that Robert Pickton spends the rest of his life in prison and prevent any re-traumatization of the families of his victims through unnecessary parole hearings. The Minister of Justice has a department full of lawyers who can prepare options that are both charter compliant and protect the families of his victims. I call on my colleagues at this table to support this motion and stand up for these victims. They've been traumatized enough. Thank you, Chair.
Thank you very much. We move to debate. Would anybody like to say anything? And before we start that, if you don't mind, to the witnesses that are in front of us, as you can tell, I think our first panel is now ended. If there's anything that you wish to have submitted to us verbally that you have not had an opportunity, please send it to us in writing. And we want to thank you very much for
Madam Chair, if I may,
coming.
just before you dismiss the panel,
Yes?
is Ms. Finley's proposal that we debate and vote on this motion today, or are you just tabling it now?
No, I'm seeking debate and a passage of the motion.
Okay, all right, sorry to interrupt. I will have some comments then, Madam Chair.
It was distributed on Friday.
Yeah. The motion was distributed Friday, so if that is her wish, yes. That was my understanding. Thank you for clarifying that, just to ensure that we are correct. So I think I'm okay to dismiss the witnesses, Ms. Finley, am I? Mr. Yeah, just so that they don't need to, yeah. So thank you very much to the witnesses on our first panel, and we very much appreciate the information you provided us.
Thank you.
Mr. Maloney, please.
Thank you, Madam Chair. I want to thank Ms. Finley for tabling this motion. I will say this individual's name once and only once. I think to suggest that any member of Parliament from any political party holds any view other than the fact that this person is a monster and should be punished to the full extent of the law is over the line. I don't want to, if I had my way, I would never hear this person's name again. Simple as that. And I think that politicizing this discussion in the way that it's been done and bringing it to this committee is a form of re-traumatization in itself and is unfortunate, given the view that I believe every member of Parliament holds. I don't propose that we debate this motion because there's nothing to debate. I suggest an amendment, a small amendment. I would take the word liberal out of the proposed wording before government, and I would remove the words and that this be reported to the House. And I believe we can move forward very quickly, dispense with this motion in a way that would be satisfactory to everybody and not have to debate something that we shouldn't be talking about and mention this individual's name ever again. So with those two amendments, Madam Chair.
Okay, so I thank you. That's a valid amendment. I'm now going to have people speak on the amendment. I've got two people up, and I apologize. I don't know who's first, but Ms. Finley and Mr. Garrison. So
I am comfortable with the word liberal coming out of government, as long as government is a capital G, because government refers to the government today. I am not comfortable taking out that this be reported to the House. This is a very serious matter, and one of the easiest ways to ensure that we don't have to mention Robert Pickton's name again would be to pass this motion, have it go to the House, and ensure that these parole hearings don't keep coming up, and then we can thankfully stop talking about this perpetrator.
Mr. Garrison, please.
Thank you, Madam Chair. I first have to express my disappointment that we did not get to hear the remainder of the testimony from witnesses, and this flags my concern that we have all-party agreement on course of controlling behavior and that we try to finish expeditiously with our hearings and any amendments and get it through the House. So this does not bode well for that. So that's disappointment. On the proposed amendment, with the amendments suggested by Mr. Maloney, I can support this motion, and I think Mr. Maloney put it very well. I'm trying not to say the name. I appreciate Ms. Finley reading out the names of the victims. I think that's much more important. My problem with the motion as it stood originally was there are other ways. If we're serious about dealing with the problems that the Conservatives have identified, then a study in the Public Safety Committee, which has responsible for the Corrections Act, is a way that could move forward for concrete suggestions. As this stands, this simply, I think, does make it a public debate and a re-traumatization without providing any solutions. So if this were being referred to as a study to look for solutions to those problems, we could have that debate. It's probably the Public Safety Committee is a better place. But with those amendments, I could support this motion today. Thank you, Madam Chair.
Mr. Housefather, please.
Thank you, Madam Chair. I just have two short points I want to make. The first is that I've had a study on anti-Semitism that has been on the table since December, and I politely waited to move it at committee until the steering committee has had the opportunity to consider it. And yet my Conservative colleagues who seem to want that continue to put forward motions without going through the steering committee, and I'm disappointed in that. Number two, I think it is absolutely unfair to start making claims that anybody at this table, any party at this table, has ever voted for anything that would change the parole eligibility of the individual mentioned in the motion. I agree with everything Mr. Maloney said. I don't think anybody here thinks anything other than this man should be in prison for the rest of his life. But this gentleman was sentenced in 2007, and he has the same eligibility he had when he was sentenced in 2007. There's been no legislative change since 2015 that anyone here has voted for that has extended his parole eligibility. There have been court judgments that struck down laws that were passed before 2015, but nobody here has been part of anything that has extended this gentleman's parole eligibility. And I think it's important to say that and to start claiming that one party or another party has been responsible for traumatizing people is exceptionally offensive. Thank you, Madam Chair. I support the amendment.
Ms. Gladue, and then followed by... No? Pas Monsieur Fortin, s'il vous plaît.
Merci, Madame la Présidente.
Thank you, Madam Chair. Well, the case of this individual is a very specific one, a particular case, and I'm amongst those who hope that he will never leave prison. Of course, there's always the vengeance aspect, but in particular when it comes to protection of the public, unless someone comes and explains that he's fully healed, otherwise I think we have to say that he's dangerously ill and he should remain in prison. Having said that, I don't have any problem with Mr. Maloney's proposal. My problem is that we have legal system, our legal system, when we say that the government ensures that he's going to spend the rest of his life in prison, is that because we want the government to withdraw the parole board's mandate? I don't think we can proceed in this way. I think that we have to place our trust in the legal system. I believe this individual should remain in prison, but I have the impression that here we're expressing a wish, and probably most of us or all of us around the table hope that this is what happens. But as legislator, can we actually say that we're asking that the government would ensure that whatever the parole board says, this individual would nevertheless remain in prison? That seems rather doubtful to me. Even though I agree with the spirit of what's expressed here, I really don't think that in a rational way we can invite the government to ignore the processes that have been established for all cases. And if we can do it for this case, then we would have to say where we're going to draw the line as to when we actually overlook what comes out of the parole board hearings. And that rather bothers me. Thank you.
Mr. Caputo.
Thank you, Madam Chair, and I'd like to thank my honourable colleague, Ms. Finley, for moving this motion and for remembering the names of the victims. The reality is that we as parliamentarians have a duty, and we have a duty to be proactive, and we also have a duty to be reactive, and too often we are reactive. Or pardon me, rarely are we proactive. Too often do we have to be reactive. The reality is that nobody wants to discuss this. But in 2007, he was sentenced, and he was sentenced to life without parole eligibility for 20 years. We're not at 20 years yet, and a lot of people don't realize you can apply for day parole before that ineligibility period. But it's incumbent upon us as parliamentarians to be reactive at times, and this is one of those times. This is an emerging issue. I'm sympathetic to Mr. Housefather, for whom I have great respect, and the motion that he put forward. But the reality is that this is a headline today. It wasn't a headline a week ago or a month ago, and we as parliamentarians have the duty, in my view, to speak, and to speak with one voice, and to speak firmly at the earliest opportunity. This is a timely measure, and I fully support it, with it being reported to the House. Thank you.
Ms. Finley, please.
I would just add this, Madam Chair, that we are not talking necessarily about changing the whole parole system. What we're talking about is dealing with serial murderers and torturers differently when it comes to parole hearings than others. There is the ability to make changes, legislative changes that would affect the way someone like this is treated through the parole system. That is what we're calling for. That's what we think needs to happen. And we are talking about something now. We are asking this committee and Parliament to take a look at this type of situation with this type of convicted offender and make changes that support victims and prevent their re-traumatization through these parole hearings. Thank you.
Mr. Maloney. And again, I remind everyone we're speaking on the amendment, so Mr. Maloney.
I'm fine.
No?
We just move to vote on the amendment.
Pardon? You move to vote on the
If there's
amendment?
no more speakers, I'm in favor of just moving to vote on the amendment.
Yeah, no, this is it. So we will vote on the amendment. Would you please remind us again what you said? I've got it, the original in front of me. Would you please?
Yeah, thank you, Madam Chair. So I would remove the word liberal, and I'm fine with capitalizing the G in government, and remove the words at the end, starting with and that this be reported to the House.
So I'm going to read the motion we're voting on now, that the committee call on the government to ensure that RP spends the rest of his life in prison and prevent any re-traumatization of the families of his victims through unnecessary parole hearings. Point. I'm going to ask the clerk. Pardon? I'm going to ask the clerk to please take the vote on the amendment. Yes.
Shall the amendment of Mr. Maloney carry? Madame Brière?
Oui.
Mr. Aria?
Yes.
Mr. Housefather?
Yes.
Mr. Maloney?
Yes.
Mr. Mendicino?
Yes.
Mr. Caputo?
No.
Ms. Gladio,
No.
Mr. Moore,
They can't all vote, so how does it?
I'm subbing in for Mr. Moore.
The subs.
Oh, substitutions can't vote? Is that
Oh.
what you're
No,
trying to tell me?
well, you're here, physically here.
All right.
Sorry. Ms. Finley,
No.
Mr. Van Popta. No. Monsieur Fortin,
Oui.
Mr. Garrison,
Yes.
The amendment is carried. Correct? I believe that ends that discussion. I'm now going to I'm going to proceed with the second panel.
I'm sorry, Madam Chair, you would now proceed with the main motion.
Okay.
We've only voted on the
Okay,
amendment.
thank you.
Thank you.
Okay, so now, Madam Clerk, can you then take the,
Is there any further debate first?
no? Can you take the, yeah, please proceed.
Shall the motion of Ms. Finley as amended carry? Madame Briard,
Oui.
Mr. Aria,
Yes.
Mr. Housefather,
Yes.
Mr. Maloney,
Yes.
Mr. Mendicino,
Yes.
Mr. Caputo,
Yes.
Ms. Gladio,
Yes.
Ms. Finley,
Yes.
Mr. Van Popta,
Yes.
Monsieur Fortin,
Oui.
Mr. Garrison. Yes. It's carried.
Merci beaucoup. Motion is carried unanimously. Merci beaucoup. Thank you very much.
Thank you, Madam Chair. Thank you.
We will now move to the second panel of witnesses, and I do understand there's some virtual as well. So I'm going to give you a minute to, although they've been tested before, I believe. And the rest, I believe, are in the room. So we will go straight to that. Okay, we're calling it back to order. It's 10 minutes after the hour. We will start with the second hour with the panelist of witnesses. Premièrement, on a Madame Emily Coyle.
First of all, we have Madame Emily Coyle, who is the Executive Director of the Canadian Association of Elizabeth Fry Societies, and then Ms. Barbara Cartwright, Chief Executive Officer for Humane Canada.
Appearing video conference, fondatrice et directrice des services cliniques.
Founder and Clinical Director, Currents Counselling. So welcome to all of you.
5 minutes to make your presentation, and it will be followed by questioning. Again, I will watch the time as best as I can, and I will now ask you to proceed. We will start with Madame Coyle.
Can you hear me? Yes? Good. It is a great honor and a responsibility, as always, to be appearing in front of this important committee. Thank you very much for having us here. We at the Canadian Association of Elizabeth Fry Societies, or CAFES, have a statement of purpose that I want to bring to you today. And it is to address the persistent ways that criminalized women and gender diverse people are routinely denied their humanity and excluded from considerations of community. Felt it was important to read that statement of purpose in the context of the discussion around Bill C-332. Intimate partner violence, including coercive control, is, as we all agree, a social issue of epidemic concern. Many inquiries and reports on coercive control, including one from this very committee, have emphasized the necessity for a comprehensive, all-government effort to eradicate pervasive and fatal forms of intimate partner violence. The Mass Casualty Commission, which I'm sure you're all aware of, specifically highlights the vital need to prioritize women's safety by shifting funding away from carceral responses toward primary prevention. Unfortunately, we see Bill C-332 falling under the category of a carceral response, and we do not support it. I ask, who are we protecting with this bill? CAFES is particularly concerned with the continuing reliance on carceral approaches to social issues like intimate partner violence because we see the failure of this type of response every day in our work. I ask that you query, why do we believe that adding another law to our criminal code will guarantee people who have experienced coercive control safety? People like an 18-year-old who is now under a life sentence because she was coercively controlled by her violent boyfriend, who then forced her to participate in the killing of his rival. Would it protect her? Or the young woman who was forcibly taken out of the limits of her probation order to be sexually exploited, only to be charged with and found guilty of breaching her conditions when she turned to the police for help. Would it protect her? In our work, we encounter these stories regularly. So many of the criminalized women and gender diverse people that we work with and alongside have endured ongoing and often appalling levels of control and violence throughout their lives, beginning at very young ages. When they defend themselves, when they push back, when they do something that puts them, quote unquote, in conflict with the law because they are trying to survive, we punish them. Criminalization has unequal and often destructive impacts on Indigenous people, Black people, trans people, sex workers, and others who struggle under the weight of poverty, addiction, mental health disabilities, precarious immigration status, and more. Unfortunately, these are not the people who will benefit from the protection of this law or other criminal legal reforms that have been enacted with the express purpose of keeping women and gender diverse people safe. In short, those that we work with are not the picture of the ideal victims. And I would be remiss if I did not narrow in specifically on two interconnected but important issues in this country. Indigenous women in Canada are more likely than non-Indigenous women to have experienced intimate partner violence in their lifetime. And we have a crisis of mass incarceration of Indigenous women and gender diverse people in our provincial and federal systems. This means that we are not only underprotecting Indigenous women and gender diverse people, but we are regularly criminalizing them. In a country that is committed to reconciliation, this has to be part of the intimate partner violence conversation and cannot be ignored. When it comes to children, when you see mandatory and dual charging laws, women and gender diverse people can themselves be and are charged with intimate partner violence. When we criminalize women and gender diverse people, we are also punishing families. Our legal system responds after harm has happened. It is not prevention. I think we all here care about victims of harm. On that, we can all agree. And so if we take that to be true, we should center people who have or will experience harm in everything that we do. A response after the fact is never going to be as good as prevention. And I completely understand the instinct to use the criminal law as a tool to assist in responding to harm, but when it is the only option that is presented time and again as a solution, then of course women and others may feel compelled to support it. And what we are essentially saying is, please pay attention to this issue. This is not the answer. Unfortunately, the criminal law has been proven at best to be ineffective and inconsistently used, and at its worst to cause irreparable harm on people who are already routinely denied their humanity and excluded from consideration of community. I have several other solutions that I'd like to propose, and I'd like to bring them during question period, if I may. Thank you so much.
Madame Cartwright, please.
Good afternoon. Humane Canada is the Federation of Humane Societies and SPCAs, with members in all 10 provinces and 2 territories, from the largest urban centres like BCSPCA to the smallest coastal communities like Happy Valley Goose Bay SPCA. These are the organizations in your ridings that Canadians depend upon to care for abused and abandoned animals, to enforce the law, to advocate for greater care and protection, and to provide resources to their communities. Humane Canada is the founder of the Canadian Violence Link Coalition, which brings together more than 40 stakeholders from both human and animal services who are interested in the links between animal violence and human violence, and the weaknesses in our justice system that often ignore this link, especially in the intimate partner and family violence contexts. We are also the founders of the National Centre for the Prosecution of Animal Cruelty and a trusted partner of Women and Gender Equality. We are here today to advocate for animal-owning survivors and their animals. More than 60% of houses in Canada own a companion animal. Women and younger Canadians are more likely to have a pet, and of those, 70% identify that pet as a family member. That makes those animals vulnerable to being used as a tool of coercive control, and it makes the human victim more vulnerable because of their love and dedication to that animal. As part of our work with pet-owning women survivors of violence and with family lawyers and prosecutors, we are aware that animals are commonly and effectively used as a tool of coercive control, and even more effectively because the link goes unnoticed by enforcement and often the courts, even if a criminal animal cruelty charge has been laid. As previous witnesses have shared, legislation to criminalize coercive control is necessary because it reflects a pattern of behavior over time as opposed to a single incident that might otherwise fall under another part of the criminal code. Similarly, animals must be included in coercive control legislation because the animal cruelty sections of the criminal code do not have a mechanism that adequately reflects the kinds of behavior patterns that are seen in coercive and controlling behavior that target animals as a tool, which is not a rare incident. In a 2018 survey, 89% of survivors reported the perpetration of animal abuse by their partners. A 2019 study of survivors highlighted what some of those acts may include. 65% reported threats to get rid of their pet. 60% reported scaring or intimidating a pet on purpose. 56% reported smacking a pet, while 50% reported throwing an object at the pet. In the most severe cases, 20% reported injury of a pet and 14% reported the killing of a pet. These findings are significant because they indicate that perpetrators of abuse are more likely to engage in those less physical and overt forms of animal abuse that leaves a victim unclear as to whether or not it should be reported to police, because it is unclear if a crime actually was committed. I want to take a few moments to share with you some survivor stories from our network that illustrates how animals are used in coercive control. A rural woman from Saskatchewan fled a violent home. Her abuser refused to feed or care for their beef cattle and their horses, so that she had to come back onto the property to do so. When she would return, he would attempt to intimidate her. The police would not intervene because they felt that if she would return to the farm, that would be evidence that she was not actually afraid of her abuser. An abusive partner threatened to poison a survivor's dog. The dog died, but she didn't have the money for an autopsy, so she was never clear as to whether or not he actually poisoned the dog. Shortly thereafter, she broke up with him, but he would call and leave messages on her phone simply saying, "Remember what happened to Bobby," which was their dog. A survivor left an abusive situation, but he refused to let her take the dog. He brought the dog to meet her at Starbucks a week later and leveraged that relationship by allowing her to spend time with the dog if she complied and did all the things he wanted. So the dog became a source of continual control and abuse. This bill needs to clearly identify that these actions are an act of coercive control. Abuse towards animals is not always considered by the law or the courts, particularly in the absence of physical injury. Enshrining patterns of controlling and coercive behaviors with explicit inclusion of animals would add clarity to the law, to law enforcement agencies, prosecutors, and criminal justice stakeholders, but more importantly, to victims and survivors. Therefore, we recommend adding animals to Section 2, Interpretation, Significant Impact. In closing, this committee recognized the role of animals in coercive control in its 2021 report on this subject. The Mass Casualty Commission's report made recommendations on animals and coercive control. And finally, we are pleased to have MP Collins' support for the inclusion of animals in this bill. Thank you very much for your time.
Thank you very much. Our third and final testimony will come from Madame Ritchie for 5 minutes.
Thank you. You can hear me? Wonderful. Thank you so much for having me. It's an honor to be here. And I first want to acknowledge with gratitude that I'm joining as an uninvited guest on the traditional unceded territory of the Secwepemc people. I am providing evidence in support of Bill C-332 from my experience working with perpetrators and victims of violence. Just to provide a little bit of information about me, I'm a registered clinical counselor with a master's degree in counseling, and I'm the owner and clinical director of Currents Counseling, which is a private counseling practice located in the Okanagan and BC Interior. I do support a team of clinical counselors. My practice is focused on working with couples and families, including those in high conflict. I have more than 10 years experience working with victims and perpetrators of violence, and I have specialized training in completing violence risk assessments and for perpetrators of family-based violence and sexualized violence. In my experience and training, coercive and controlling violence is often disguised or mutualized. So you'll often hear language like domestic violence or relationship conflict, which doesn't identify what is going on and who's doing what to who, or ideas that justify the controlling behavior. So language like it's in her best interest or she's not good with money, which then justifies the controlling of the family finances. Systems and professionals are often complicit in this mutualizing and disguising of the violence because it's hard sometimes to identify. The victim is often pathologized and blamed for the violence and control being perpetrated against them. It can be overt or subtle and covert. The violence is often concealed, and resistance to violence is often minimized and retaliated by the perpetrator. Often the victim can believe they're responsible for the violence. However, when we properly assess for violence, we learn many things about it. So we learn that the victim often has insider information about what happens when they resist the violence. So when you start to ask the victim questions like, what would happen if you left the relationship? They tend to be able to provide descriptions that reveal their real fears for their safety. Victims of coercive and controlling violence often have a lot of fear of leaving the relationship. And I do have an example from a personal client that I had the privilege of working with a number of years ago. The client, I've changed her identifying information, and I'm going to refer to her as Tracy. Tracy initially attended counseling with her husband, who was nearly 30 years older than her. She's an Indigenous woman who at the time was in her early 20s, and she was with a white man in his 50s. He was an incredibly wealthy man. When I met them, he wanted to control the narrative of the reason why they were in therapy. The reason why they were having relational issues was because she had trauma and also because she had a drinking problem. When I met her individually, I learned that her life was very closely controlled. She had to attend the church she attended. He controlled all of the family's finances. Her movements were closely monitored. She was not able to establish credit or independence. And when she asked to further her education, he created many barriers to this. She had to hold his hand when they walked, and if she didn't, there would be conflict when they got home. She was isolated from her friends and family. There was strict monitoring of her weight and image. He coerced her to get a breast enhancement that he paid for that she truly did not want. She also had to dress conservatively and maintain a small physique. As a response to the violence she was experiencing, her mental health declined rapidly. She was drinking a lot, and at times while she was drinking, she would act aggressively towards him. When she started to leave the relationship, the retaliation was swift. She was out of town for a medical procedure when he hired a lawyer and successfully was able to position a case to a judge for a no-contact order against her without her consent. When she was released from the hospital, she realized she could not only go home, she could not go home, but she could not see her children unsupervised. Her mental health continued to decline, and she got a DUI. And she now had even fewer options and had no choice but to return to the relationship. This woman will navigate this her entire life unless the perpetrator is held accountable for his actions. There's so many other victims that have to navigate the realities of having their lives not only controlled, but face real consequences when they try to stand up or take a position. In summary, Bill C-332 provides legislation to not only offer clear language to what is happening to the victim, it also provides recourse to support victims experiencing coercive and controlling behavior, and invites accountability for the perpetrator and consequences for the behavior.
Thank you, Ms. Ritchie. We'll now move to our 6-minute round, and we will begin with Madame Gladue.
Thank you, Chair, and thank you to all of the witnesses for being here and helping us with this very important subject. Every 6 days in Canada, a woman is killed from intimate partner violence. And it's clear to me that none of the actions that have been put in place work. Many of these women don't leave. I certainly am well acquainted with coercive control. And even if they get a no-contact order, it doesn't work. People violate them, nothing happens, and then they kill their partner. And so I'd like to start with Ms. Coyle. You talked about preventive actions that we might take. Could you elaborate on those?
Thank you so much. I think first and foremost, and this came out of the recommendations from the Mass Casualty Commission, give organizations that work with survivors of violence epidemic level funding and make it ongoing. If a person who is experiencing coercive control has access to a safe place to escape and can bring her children and her pets with her, then that is one of the first hurdles. I understand that this bill cannot require funding to be, brought forward, but I do think that that's an important piece of this discussion. If you want awareness to bring awareness to what is known as coercive control, then start a very public campaign about it. Teach children about it in school. We need to start early. Provide financial supports and training. All of the people who've appeared before you have spoken about training and employment for opportunities for people who are escaping coercive control. Provide adequate funding for legal aid lawyers and legal aid certificates so that lawyers who are representing criminalized survivors of coercive control can actually tell their stories. And finally, we should be utilizing the defense of coercive control much more than we are criminalizing coercive control. Thank you.
Good. And now another question for Ms. Ritchie. I see in the bill that there is a defense where you would claim that what you were doing was in the person's best interests. And while I can see situations where that might be true, somebody that has Alzheimer's or something, you have to, take care of them, make sure that they don't harm themselves. But in fact, one of the characteristics of coercive control is that the perpetrator is telling somebody that they're doing this because it's in their best interest. So could you tell me whether you think this defense as it's written is appropriate?
I do think it's appropriate as it's written because the perpetrator is in control of the victim. And so what the perpetrator is doing is using specific tactics in order to manage the victim, to make the victim feel as though they're responsible for the violence that's being perpetrated against them. So they will convince the victim that it is in their best interest around controlling the family finances, or that maybe in subtle ways that they maybe shouldn't be able to go out and see family and friends. So sorry, excuse me, I'm just a little bit nervous.
No, that's okay. And really, that's exactly the point. I mean, although the perpetrator may say it's in your best interests, why should it be able to be used as a defense that I was doing it because it was in their best interests? I think there's a problem there.
Right.
Let me ask one other question to you, and that is, they've suggested that there be this 2 years if you're experiencing this with a partner that you've been with within the last 2 years. Do you think that there should be any kind of a limit at all, or should we just remove that 2-year part?
Well, I think you're trying to establish a pattern, and we know that sometimes this can happen quite quickly, where there's this sort of grooming behavior, and this kind of pattern of behavior starts soon. I don't know exactly how long of a time frame there should be, although I do think there should be a period of time where you can start to look at the behavior over time, because in the beginning, it can look kind of subtle and it can develop quite, become normalized in the relationship and develop into something more significant. So I don't specifically have a timeline in phrase, but I do know that some sort of a timeline in order to establish that pattern would be helpful.
Yeah, very good. We did hear that, over time, especially if you have children together, that sometimes the behavior can escalate. I have another question for Ms. Cartwright. England put in their legislation, a list of things that were indicative, of course, of controlling behavior, sort of including but not limited to kind of phraseology. And I see that they put in here threatening to hurt or physically harming a family pet. Do you believe that the Canadian legislation should contain a similar list with something like that?
Yes, we had put forward 2 amendments. One in recognition that our human services partners feel that there needs to be a definition of coercive control, and so we recommended in our submission to use the one from the Divorce Act, since it also recognizes animal violence in it. And then also to include it in the significant impact section, that the impact not only to her ability or the victim's ability to protect themselves or their children, it should also be to care for or protect their pets.
I may run out of time on this one, Chair, but my question to all of them is, if you consider the UK legislation, the Scottish legislation, and other legislation, which one do you feel that we should closely model after?
And I will ask you to keep that thought for the next. So I will now go to Madame Brière, s'il vous plaît, pour 6 minutes.
Merci, Madame. You have 6 minutes. Thank you, Madam Chair. So I'm going to put my questions to Ms. Coyle. You have said that the justice system had overrepresentation of people from racialized communities and so on. And in the bill, we use this concept of fear, and that fear has to be proven. Do you think, well, first of all, I'd like to hear from you on that aspect of fear. And would the effect be to further victimize the victim? The fact that they have to be examined and cross-examined, do you not think that that would actually re-victimize them?
I do think that that is a problem. I think the legal system as it exists, we know that most of the people who've experienced intimate partner violence do not come forward. We know that many times if they have come forward and they are brought before the courts, that they are made to relive the trauma that they've had to endure. And often if it's a specific action that has been taken, then maybe we can just focus on that particular action. But when it comes to coercive control, because it is, something that is experienced by people over long periods of time, that is very nuanced, you're going to have a person who's in front of the court who's experiencing cross-examination on multiple points of pain and trauma in her life. And so we worry very much about what that would look like for the person who's been harmed.
Est-ce que vous avez une solution? Do you have a solution to offer, or what would be your recommendation to deal with that?
I mean, we've already discussed training, and so training is always important when it comes to the legal system, when we're talking about prosecutors, criminal defense, and judges, understanding the experiences of people who've experienced intimate partner violence. Not criminalizing coercive control until we've figured everything else out might be another way that we could go. And certainly, I think it's important to try to prevent people from being harmed in the first place. And so how do we do that? It's a huge task, but we have to tackle it, right? We have to tackle poverty. We have to tackle racism, misogyny. These are big issues of our time, and we can be creative here. This is the opportunity to do so because we're talking about intimate partner violence all the time now, and we understand the problem with it. And so we can't see the criminal law as the Band-Aid solution to this huge gushing wound that we have.
Merci beaucoup. Le projet de loi... Thank you very much. In the bill, it proposes a new definition And also this concept of link is introduced, whereas in the criminal code in section 2 we've already got the definition of intimate partners. Do you think that we should refer to that section 2 definition rather than including this new concept in the bill?
Yeah, I think we have a good definition of coercive control. I'm not an expert on coercive control, actually, so I would defer to those who are. I think one of the recommendations that came out of many of the inquiries into intimate partner violence was to create a panel of experts on coercive control, and that might be something else that we could do in order to inform steps that we are taking moving forward. I also wanted to say, when it comes to Section 5 in the proposed law around the defense of best interest, I worry about the infantilization and that places on the person who is bringing forward a claim of coercive control. Where could a claim of best interest ever be used as a defense would be a query that I have. Anyway, I'll leave it there.
À la fin de vos remarques,
At the end of your comments, you were starting to give us a list. Would you like to continue, please, with that?
It's exhausted, but I will be presenting you with a brief by the end of this week, so I'll include it there as well. Thank you.
alors ma prochaine question serait par rapport.
So my next question is on children. Do you think that when we're talking about coercive control, should we include children in the bill? And do you think that there should be an aggravating factor included when you've got a child under 18 who is actually involved in this situation?
So it's hard for me to talk about what to include in a law that I don't actually think should be moving forward. But I think when I said we criminalize women and gender diverse people, when we criminalize them, we are punishing families. And so when a caregiver is charged, and I have this in my notes and I didn't say this, and is held on remand, so denied bail for even a short period of time, this can have lasting detrimental effects on her keeping her job, keeping her housing, and caring for her children. And so it is the children who will suffer if their parent is removed from them with a charge of coercive control. And we actually know of innocent people who will and will probably plead guilty to violence toward their partner so that they can leave jail and get back to their families faster, and then they will have a criminal record that will follow them for the rest of their lives. So it's a really nuanced issue that we have to examine closely.
Okay. Merci beaucoup, Madame Brière. Merci.
Thank you very much, Madame Brière, and thank you to the witnesses. And now we'll turn to Mr. Fortin for 6 minutes. Thank you, Madam Chair. Thank you, Ms. Cartwright, Ms. Coyle, for being with us today. Now, I had certain questions, but now I'd like to come back to what's just been raised by Madame Bruyère. It's led me to other questions. I wonder whether there's a bit of a trap with this question of children, because I don't want to draw shaky comparisons between children and pets, but what I've understood is that we're not going to punish the conduct towards children, but the children would be an indirect victim, just like the animal. That's, for example, if you threaten your spouse saying, if you don't do what I tell you to do, then I'm going to take it out on the dog. So the dog is a kind of indirect victim as well. But the person who's actually a victim of this controlling coercive conduct is actually the spouse, male or female. Is it the same reasoning that applies to children? For example, the fact that a child, as you've said, is going to suffer an impact, of course, if there are charges laid in criminal proceedings between parents. Is that your view on things, that the child would become an indirect victim of the situation playing out between the two parents, for example, or the controlling and coercive conduct vis-à-vis a child, even if there's no spouse, should also be covered by an offence under this bill?
Oui.
Okay. Merci. I don't think I can answer that question because I don't think I have the expertise to answer that properly. So I'm just going to remove myself from answering that at this point. Thank you.
Sur la question des...
So we talk about controlling coercive conduct repeatedly or continuously. So, Madame Coyle, is there a limit, a minimum limit? What's a minimum time can be considered as sufficient to say that a controlling coercive act, for example, holding back a passport or identity papers, is one single act enough? Or do you think there's a minimum number of acts that need to be committed before we can actually talk about a repeated and continuous offence?
So again, I'm not an expert in coercive control, but I will say this. What we do know is that the existing laws that surround intimate partner violence and the way that women and gender diverse people are criminalized are often manipulated by people who are abusing their or harming their partners. And so if there is a way that a person could manipulate the system to harm their partner, they will do it. And so it's going to be really difficult, I think, for our legal system to respond to such a nuanced and complicated way of harming someone.
Merci, Madame Coyle. Madame Ritchie.
Thank you very much, Ms. Coyle. Ms. Ritchie, I don't know if you heard the questions that I put to Madame Coyle. I'd like to come back to the same questions. So first of all, this question of it being repeated and continuous conduct, should there be a minimum number of acts or frequency? What do you think about that?
Thank you for the question. I don't know about a specific number, but I do know that you will see a pattern of behavior, and you'll see a pattern of behavior that starts fairly early on. Where it may pique her as a bit of a red flag, but not enough for her to disengage necessarily from that perpetrator. So while I can't speak to the number of acts, you will start to see an increase in behavior, and you'll start to see that once she's more vulnerable or once she's more involved in the relationship, you'll start to see those increase. So yeah, no, I can't speak to a specific number, but I think establishing that pattern of behavior and watching as it increases over time.
Merci, Madame Ritchie. Madame Ritchie, également sur la...
Thank you, Madame Ritchie. Once again, on the question of children, when it comes to your reading and understanding of the bill, we want to ensure that children are included as co-victims. So do you think we should consider children as indirect victims of controlling conduct carried out from one parent towards the other parent? Or should we consider coercive and controlling conduct of one parent towards the child directly?
40 seconds
left. I think the children are direct victims, and I can think of many examples where a child of a perpetrator who's engaging in this kind of behavior, the child will identify because of the behavior of the perpetrator with the perpetrator and believe that the victim is the problem. And I've seen extreme alienation where a child is so supportive of the perpetrator that they believe and they want actually no relationship at all with the victim, who's the mother.
Merci. Thank you.
Merci.
Mr. Garrison, please.
Thank you, Madam Chair. I want to start with a question to Ms. Ritchie and, of course, express thanks for the frontline work you do with these issues. To start with, I'm going to ask maybe a somewhat leading question, but since I began working on this issue 3 years ago, we've had lots of women contact our office saying that they hadn't recognized that they were a victim of coercing and controlling behavior because no one had ever talked to them about it. And I wonder whether you find that in your counseling practice that people somehow think it's their problem, an individual problem, and something that's not really recognized. Do you find that?
Yeah, that's exactly what we find. Very rarely do I see a client that's initiating services because their presenting problem is that I'm a victim of controlling and coercive behavior, violence. What we see is them coming in for maybe expressing that they're feeling depressed or anxious or overwhelmed or stressed, or they have trauma or relationship issues. And it's through these kind of through an assessment of what's going on in the relationship that you start to see this pattern of behavior. Now, they might even mutualize it in the beginning and say very blanket statements like everybody fights, or we have some conflict and I contribute. And it's actually digging deeper into that and finding out who is doing what to who, the level of vulnerability, et cetera, that you start to see that this is what's actually happening.
And do you find this a recognition among victims that coercive and controlling behavior is a form of violence in itself, or is it excused as being nonviolent?
Yeah, I think it's excused as being nonviolent. I think when this type of behavior is nuanced and subtle, and it's confusing to the victim because it is a pattern of behavior over a period of time often. They may recognize some parts of it that they don't like, or it could also be more subtle where they're slowly not allowed to spend time with friends and family, and that's justified for various reasons. I'm not sure if you wanted me to continue.
I guess just to add to that then, do you think that this bill would help people recognize that problem earlier on and perhaps seek assistance earlier on?
Yeah, well, my hope would be that, again, this is another tool. I'm hearing the other witnesses, and I understand these positions, and I agree. But I see this as being an opportunity for us to point at legislation with victims of violence and perpetrators of violence and say, this is, use clear language to what's happening and look at the legislation and look at potential options for victims, and also inviting accountability for perpetrators.
Thank you, Ms. Ritchie. I'm going to turn to Ms. Coyle. And again, thank you for being with the committee again. And I was hoping you would be here, even though I know and knew in advance your position on the bill. I guess I'm going to ask you somewhat argumentatively. Some people say that what we have now is a failure to recognize coercive control as violence. And therefore, rather than a new criminalization, what we're doing is taking the point at which we criminalize and moving it from bruises and broken bones to the behavior that leads to the bruises and broken bones. So it's not a new criminalization, but it's moving the point at which we recognize the behavior as criminal. What would you say to that argument?
Anytime that there's a creation of a new criminal law that will result in people being sentenced for behavior, you're going to see an increase in criminalization of people who are already overly criminalized. And that's the only point that we wanted to bring here today. We are not in any way arguing that this isn't an issue. We all agree that it is an issue, and it's an important issue. And we are really grateful that we are discussing this issue at such length. I think it's wonderful that this continues to be something that is brought forward. But we caution, and we continue to caution, as we do with everything, that any time that we create new opportunities for people to be caught up in the web of criminalization, it's very hard to extract yourself once you're in it, and it becomes a form of harm itself.
I think it's a very valuable perspective that you always bring to the committee is that reminder. I've got to do, I guess, one final question to Ms. Cartwright. Do you believe the bill as is written does not cover abuse of pets as part of it, or are you simply arguing that it would be better to make it more explicit?
Both. I don't think it includes animals, and it needs to be made explicit because our society and the way the criminal justice system is set up is animals are often pled out animal offenses. If they are there, they're often not recognized by the courts. And so the explicit need to refer to animals will provide the judiciary, the prosecutors, and the enforcement officers, as well as the victims, the understanding that that's what's happening to them.
When I originally was dealing with legislative drafters on this, one of the arguments that they made was that exhaustive lists in the UK are included in prosecutorial guidelines and not in the actual legislation because of the dangers in the way our criminal system works. If you don't list everything, then judges may decide if something's not on the list, it's not covered. And so would it be sufficient, do you think, if prosecutorial guidelines included the specific example of pets?
I would recommend that it stays in, and where we had suggested around significant impact, it already mentions the victim's ability to care for herself, her children. So it makes sense to add the pets because it sees the whole family or the whole system. And I would broaden that out myself to say all animals that are owned by a victim, and so that would include farmed animals.
Thank you very much. So to take us to time, what I will do is have us go to the second round, 3 minutes, Conservative, Liberal, and 1.5 minutes for the rest. And that'll take us to time. So I will call on Mr. Caputo for 3 minutes, please.
Thank you. Thank you to the panelists. Ms. Coyle, I was surprised that you're not supportive of the legislation. And the reason is this. We deal with what we call a cycle of violence, and it perpetrates. And I think that one of the examples you used is that a woman will be subject, or a victim will be subject to cross-examination. And that's not right or not fair or not appropriate. We call that secondary victimization when that goes wrong. But what's the alternative? The alternative is repeated violence, and then repeated violence after that, and then repeated violence after that. And oftentimes, we just heard the statistic today, every 6 days a woman is killed. So when we bear that in mind, how can we not criminalize this behavior?
I think that we've had discussions about criminal law before in this committee, and it does sometimes come as a surprise to people that an organization that works with the most vulnerable women and gender diverse people in this country doesn't support the creation of new laws that would potentially protect them. And the reason is because we see that the law is used against them time and time again. And so, I even think of the example that was used by my co-panelist. This person's partner started all the actions behind her back. She got a DUI. She became the one who was criminalized in the end, and he was not criminalized at all. And these examples we see time and time again. So it's not just, theory. This is what is happening in practice. People are being harmed by the criminal law in our country because we don't have a fully functioning system that is able to protect people and prevent harm from happening.
But that therein is the problem. She got the DUI because of his coercive conduct. And what are we trying to do here? Penalize the very thing that was at the genesis of her downward spiral.
Exactly.
So if that's the case, why are we not criminalizing it?
I know. You would seem that we would be on the same page about this, but you can see what happens. Coercive control is so hard to prove, so hard, and he was somebody who potentially could have harmed her in a physical way. And there are laws on the books that are already dealing with potentially financial abuse, physical abuse. These are the kinds of things that we could utilize already but aren't being utilized in our criminal system.
As a former prosecutor, I can say there are already enough impediments to dealing with intimate partner violence and related offenses, and I will say that I fully support the broadening of it because this victim group, it spans relationships of the rich, relationships of the professionals, and things like that. So when you talk about just dealing with poverty, things like that, that's the macro issue. The micro issue is the person that's in the relationship today, here and now, could end up dead, and statistically is most likely to end up dead.
Thank you.
And that's why we need to address this.
Thank you
Sorry,
for that.
I had questions for Ms. Ritchie, but
Mr. Arya, for 3 minutes, please.
Thank you, Madam Chair. Madam Chair, I fully support the objective of this legislation, but at the same time, I also recognize that we can't fully change the behavior, but by just passing the legislation, education and training also has to go hand in hand with it. I'm glad that we 339 members of Parliament, we can technically pass any legislation. But the process in which this is passed allows us to listen. For example, Ms. Jennifer Koshan, the professor of the Faculty of Law, she did mention the unintended consequences of this legislation and that some of the things are unclear, undefined, how it affects. And Mr. Emily Coyle, it is some of the sentences you said stuck to me. You said that the criminal law cannot be used as a band-aid for a gushing wound we have. And you also said that criminalizing behavior will affect already the people who are overwhelmingly criminalized. And the criminal justice system, we see that most of the people in our jails are basically indigenous people and racialized communities. So it is very difficult for me. Obviously, when we hear the stories of how this intimate partner violence has affected individuals, that we need to take action. You know, our blood boils. We need to have them. We have to throw them in the jail, lock them up, and throw the key. That is the first reaction we have. But we also have to listen to people like you and see that we don't overreact. I don't have any solution. I'm sure that you have offered your thoughts. Hopefully the committee will consider more. And if you have anything more to add, you can with whatever the few seconds that may be left, or you can always submit more stuff in writing.
So if you have anything to say for, you've got 45 seconds.
45 seconds? Okay. I think I wanted to bring us back to the issue that I narrowed in on in my remarks, which is the fact that we have a crisis of mass incarceration of Indigenous women and gender diverse people in this country. In the federal prison system, 50% of the people that we see are Indigenous, and they, as you all know, make up only 4% around there of our population. And in the provincial jails, that number is even higher. And why? It's because we are criminalizing Indigenous people in this country at higher rates than we are anybody else. And the number of women who are being incarcerated is growing faster than any other, than the number of men, for example. And so we need to pay attention to that. And if we continue to address social issues with the criminal law, we will continue to have this mass incarceration issue.
Thank you very much.
Thank you.
Monsieur Fortin, pour 90 secondes, s'il vous plaît.
90 seconds, Mr. Fortin. Thank you, Madam Chair. I'll put my questions to Ms. Ritchie. When it comes to the best interest of the person, that rather bothers me. It seems that it could be a factor to establish that mens rea is not present. If we said you exercised inappropriate control over someone, but if it's in their best interest, if somebody wants to jump off a bridge and we hold them back, there are certain examples where it's quite clear-cut, of course. But why are we introducing this into the bill? Do you think it's a good idea to add this part about the best interests of the person, Section 5, that says if an accused is charged with an offence, it is a defence to say that he was acting in the best interests of the person, the victim, or should we leave it up to the courts to interpret what would actually constitute an offence establishing mens rea and actus rea? So could you perhaps clarify me on that question?
Well, I think
Less
it
than
would
30
be appropriate.
seconds left, so
Thank you.
please go ahead.
I think it would be appropriate for the courts to establish that, because I think it is important when you are acting in the best interests of someone that's not misunderstood. And so looking at specifically how that is used in a coercive way, I think it would be helpful to leave it in there and let the courts distinguish that.
Thank you. Merci beaucoup. Monsieur Garrison.
Thank you very much, Mr. Garrison.
Seconds. Thank you.
Thanks very much. I just wanted to clarify that the bill doesn't say just claiming it's in the best interest is a defense. It says you have to demonstrate beyond a reasonable doubt that it's in the best interest. So I think we got off a little there. I want to go back to Ms. Ritchie for a final. I think people around the table know I regard the Okanagan as my second home. What resources do you find available? Because I've heard people talking about we need other resources, and I think it's a particular problem outside urban areas. So do you find that there are resources available for women seeking to leave those relationships in the communities that you serve?
I find that there are resources. They're just not overly collaborative. So a very resourceful victim can, find resources, but often it takes an enormous amount of resiliency and work in order to do that. So there are resources, but I think if they were more collaborative and connected and accessible, then, we need more. We definitely need more.
Thank you very much.
Thank you, Mr. Garrison. Thank you very much to all our witnesses. Again, I've heard some of you say you will be submitting further information to us, so thank you for being here this afternoon. And thank you to our colleagues here on the committee. We'll see you on Thursday morning. Thank you so much. Committee is adjourned.